Thank you for joining us at the Victorian Chamber of Commerce and Industry. This is webinar 2 in terms of looking at the new workplace manslaughter laws and particularly focusing on how employers should prepare for and respond. My name's Ian Wallis, one of the senior health, safety, wellbeing consultants, and joining me later in the session will be Phyllis Edwards, also from the Victorian Chamber of Commerce, and we're both part of the health, safety, wellbeing team here at the Chamber, and it's our pleasure to assist you today. So thank you for attending, and I guess the items that we're going to cover today are really just, there may be a couple of people who missed the first webinar, so we will just quickly review the laws and refresh. And then we will start to think about what legal precedents are there and what we can learn from those legal precedents. There aren't that many. There is one in Australia, and we do need to look at the UK and their experience to gain a sense of how these laws will work. So we'll do that somewhat today. And then get into what we believe is the right way to approach these laws for pretty much all employers. So we're going to step through a 5-step process to give you some, a useful procedure to follow, to prepare for and continually ensure that you comply with these laws. So we'll get into the content, I guess. So. As we said last week, these laws are due to commence on 1 July 2020. Now, last week on Friday, there was a few questions around retrospectivity of these laws. Generally, these laws are not retrospective. So they do commence 1 July and from that date forward. However, there is an inclusion. So if there is negligent conduct occurring now or before, and that continues to occur after 1 July without the appropriate controls and corrections, then that is a potential situation that could trigger these penalties as well. But generally, they're not retrospective, and so they commence 1 July. So a quick refresh, the 2 offences that we are talking about is new sections in the OHS Act. So it is an addition to the OHS Act where section 39G1 talks about a person, and the legal definition of a person includes organisations. So a person who is not a volunteer must not engage in conduct that is negligent, is in breach of an applicable duty under the OHS Act and causes the death of that person. And the penalties, notably, are up to 25 years imprisonment. And as we've been talking about, the draft bill was commenced at 20 years, but recently we have had another legal amendment for all manslaughter penalties that will also commence on 1 July, and that has amended the imprisonment to up to 25 years. So if you're a little confused by that, that's the reasons for that. A recent change that increases the imprisonment term to 25 years. Also, for a corporation, up to 100,000 penalty units. So that equates to just over $16.5 million as a potential ceiling, a maximum that is available to the courts. So this, the first offence includes organisations such as body corporates, partnerships, unincorporated bodies and unincorporated partnerships, including then as well self-employeds. Point to note, and again questions around volunteer board members and directors and corporate officers, they are expressly excluded. A feature of these laws is that typically they don't want to frighten people off from contributing their voluntary time. So when people are truly volunteers, they are exempt from these particular offences under the OHS Act. The other laws that apply through the Corporations Act still apply. So it's a point to note for volunteer board members that they are expressly excluded from the OHS Act in this sense. The second offence is section 39G that relates to a person, and this is a person who is an officer, a corporate officer, again as defined under the Corporations Act. And under this legislation, this Victorian statute is excluded if they are a volunteer. So that person who is an officer must not engage in conduct, that same language, is negligent, is in breach of an applicable duty under the OHS Act, and causes the death of that person. So very strong focus on cause and causation and causal links. Again, up to 25 years imprisonment is the potential new penalty. So the term officer is primarily focused, and the stated intent of these laws is focused on the senior people in organisations. But this may actually extend to the most senior person who might be managing a site. So this could extend to site managers per se. There is a case before the courts at the moment where a senior New Zealand engineer has been charged as an officer for a serious incident on a decommissioned construction site, a decommissioning process, and the senior engineer from New Zealand has been charged as an officer under the OHS Act. Now, whether that's successful or not remains to be seen. So there is an intent of these laws in particular to focus on those who manage and control various workplaces, and there is a chance that it may be site managers or branch managers may be included. So the applicable duty defines, I guess, how far and what these penalties apply to. So the duties imposed on Part 3, the general duties under the OHS Act 2004. But there are two specific exclusions that are noted. And those exclusions are excluding employees under Section 25 and excluding an employee who is subject to a reckless endangerment prosecution. They are the only exclusions, which means all other applicable duties under the OHS Act are available to the courts and to WorkSafe to prosecute for a workplace manslaughter charge. And this is an important point to note. So the general duties of care under Section 21, duties to monitor in Section 22, duties to others in Section 23, that's the members of the public or work experience students, etc. The managers and supervisors' duties under those who manage and control under Section 26. Designers, manufacturers of plant and substances, suppliers, installers and importers are all covered under the applicable duties listed in Part 3 of the Occupational Health and Safety Act 2004. So by excluding employees in two sections, that means that all other applicable duties apply and are available for these potential prosecutions. Now, it is the stated intent of these laws, perhaps not in the laws themselves, but certainly in the explanatory memorandums and the Hansard record in Parliament. It's certainly the stated intent that there is recognition that some rogue employees exist, but it's an important point to note that they are not excluded other than from these penalties. They are still able to be prosecuted, rogue employees, under Section 25, a failure to cooperate, or Section 32, reckless endangerment. So those two sections are still available under the normal functions of the OHS Act. The negligence test is one we need to look at. So the performance standard, I guess, or the test the courts will apply is very consistent with the criminal negligence standard set in common law. And so that standard involves a great falling short, and please note the term, the great falling short of a reasonable care standard, a standard that is taken by a reasonable person in the circumstances. So a great falling short. So it's a serious, negligence test. And also another point to note in Part B, these laws apply to risks associated with not only death, but risks associated with a serious illness and injuries. And these have been specifically included. And there's recognition of the chance of these serious injuries and illnesses may lead to a fatality at some later date. So things such as, workplace illnesses developed through exposure, whether it's carcinogens, asbestos, silicosis, all then become potentially available for the workplace manslaughter charge. And also then creates a much longer term set of circumstances that are included. Now, the reasonable person test, we've included a definition at the bottom of the slide here. So this standard requires one to act with the same degree of care, knowledge, experience, fair-mindedness and awareness of the law that the community would expect of a hypothetical reasonable person. And by the way, that includes a reasonably behaving organisation. So it's a reasonably good, well-regarded definition. And the test is a great falling short of this standard. So one of the focuses of this second webinar is to look at what we can identify in what precedents are available. There is one case in Australia to date that we should and do need to consider. And that case has only just in the last few weeks been finalised in Queensland. And so this case is an employer, a person's conducting business or undertaking. An employer in Queensland has been convicted and failing to separate pedestrians from mobile plant. And this has become the first entity under the Queensland version of the industrial manslaughter provision or legislation of that, under Section 34C in Queensland. And the company and its two directors have both been found guilty of reckless conduct as well. So one prosecution of the company and two prosecutions under reckless conduct, not manslaughter, of its company directors. So the company directors have been sentenced just a couple of weeks ago on the 11th of this month to a corporate penalty of $3 million. And the directors received a 10-month wholly suspended jail sentence for 2 years and received that sentence each. The case was Brisbane Auto Recycling, and the 3 million was out of a maximum of 10 million available to the courts for negligently causing the death of a worker. So then this worker was unloading tyres or stacking tyres on a truck and was struck by a reversing forklift at a wrecking yard in Rockley. In May 2019, yes, that is when this occurred. And so we've just seen this prosecution handed down and these penalties handed down. Keep in mind that Queensland have had these laws in place since 2017. And so this is the first one. So this is the only Australian precedent we currently have for workplace or industrial manslaughter. These laws in Victoria have been heavily drafted and based on the UK experience. The United Kingdom have had these laws in place for quite a while, for 11, 12 years now. And there was a fair bit of research done around their experience, and our laws in Victoria have been heavily based on these. Now, a few points to note. So the Corporate Manslaughter and Corporate Homicide Act 2007, that in Britain supports the Health and Safety at Work Act 1974. So this does not include individuals. Corporate officers and others who are senior in workplaces are not included in the British model. In Victoria, they have been included. So this is a key difference. Clearly, punishing or penalising an organisation, sending an organisation to jail is not an option. So there are no jail options for corporations, just financial penalties available. Now, in the time period that these laws have been in place in Britain, there have been a maximum of 26 corporate manslaughter convictions over those 12 years. And that's with the majority of those pleading guilty and therefore not contested or challenged through the courts. 25 of the 26 are small and medium businesses. And there's a couple of reasons for that. There is a strong need for a strong causal link between a corporation's behaviour and the fatality. So only about 5% of all fatality convictions in British workplaces are heard under the corporate manslaughter prosecution. So only 5% of all fatalities at workplaces in the UK. Now, if we translate that to our future experience, that's likely to be maybe 10% of our workplace deaths will result in a workplace manslaughter charge. But that is yet to be determined. But all of those, pretty much most of them are small and medium businesses because of the close relationship between directors being on site, conducting and controlling activities. The highest penalty paid in the UK to date, out of the potential, from memory, £10 million, was £1.2 million. So an average of, about across all 26, an average of £300,000. Have been the findings. Now, this was some source of concern because even though they introduced the laws, the penalties did not increase a great deal. And so the UK government introduced some sentencing rules in 2016 to guide the courts, to require the courts to impose some more stringent penalties to try and make the laws a little more effective. Another point to note is the average time from incident to prosecution is around 3 years on average. And I'll come to that in a moment because I'll speak to that actually now. The Victorian version of these laws has had the statute of limitations of 2 years removed, and that's for this reason, because these are complex and difficult investigations and they take longer to generate and finalise. So Victorian version has no statute of limitations for this reason. They are longer investigations. Now, another point to note, statistically, the fatality rate in the UK does remain flat. It has not changed a lot, but non-fatal injury rates have declined since these changes by almost 40%. So there's been a significant impact, but just not perhaps what was originally intended. So yes, our laws are heavily drafted heavily and based on the British experience. Another point to note is the British version excludes some public bodies, such as emergency services, etc. So there are a few exclusions there. Again, there is a very strong causative requirement between the conduct and the fatality. And we will, of course, need to be patient over the next few years to see how our Australian legal precedents develop and materialise, because we only have the one in Queensland at this point. A few examples of the British cases, just so we can see what they look like. So something that is actually disturbingly familiar to an incident that occurred in Victoria late last year was a person inside a large steel bin, cleaning the inside of the bin while a forklift was being, the bin was on the tines of the forklift. So a person in the bin on the tines of the forklift. The director driving the forklift, unlicensed, I believe, and the tines did not fit the bin, and it toppled off and crushed the employee in the process. And so JMW Farm Limited, the corporation, was fined £187,500. A second case, again, these two are small businesses. Martinisation in London Limited, a company with a turnover of just under £10 million, was fined £1.2 million because two persons fell from a balcony while hoisting a sofa up from the pavement below, and they fell to their deaths. The company also had a poor history, and prior inspectorate improvement notices were ignored, and so there was an effort to penalise this company for long-standing poor behaviour. So, as we said, most British companies have been small business, but the one large business that has been found guilty is a company with a complex corporate structure. The parent company prosecuted in 2013. So CAV Aerospace Limited, and based with a range of sites, but in particular a subsidiary site in Cambridge where this incident occurred. So a large company, 460 staff or so, and with a turnover, annual turnover about £73 million, but a complex corporate structure is a point to note. These complex corporate structures have been difficult to prosecute over the decades because of what's called the identification doctrine. So in this case, the employee was crushed by stacks of metal billets stored at a Cambridge location. The company was having difficulty in controlling the amount of incoming goods. The sole director repeatedly ignored concerned emails from site managers. Now, please note, repeatedly ignored, and an OHS consultant had also given warnings in strong terms as per the court's comment. And various solutions were rejected solely on cost grounds with no real sense of reasonably practicable or a risk assessment and an understanding of risk being applied. So due to the collective management failings, again, the court's terms, leading to the death in a warehouse and a $600,000 penalty in this case. And that was 2013, prior to the sentencing rules, new sentencing rules being put in place in the UK. So this is the only large complex corporation precedent that we may have, at least for now. So what does this mean for us, employers in Victoria? So we've summarised this previously this way. The laws, although they won't impose any new obligations, what they do is strengthen the penalties under the existing applicable duties of care under the OHS Act. And the threat of these significant penalties is motivating and should motivate organisations to review their strategies and in further improve if needed to minimise those OHS risks that may lead to serious injury, illness or fatalities. To help with this, the Chamber is in the process of developing a wide range of resources. These webinars are included, and we have a range of tip sheets and fact sheets, but also some self-assessment tools and templates, and some video-based vignettes that will help instruct and assist. We also have, as we've said before, the team of health, safety, wellbeing consultants who are here to advise if further information and detail is needed. So the process that an organisation should go through really fits this description of corporate officer due diligence. So leaders of businesses really need to follow these types of behaviours. And this is really the only way that an organisation will be able to avoid these types of prosecutions. So these behaviours that the leaders of businesses should adopt are acquiring and keeping up-to-date knowledge of health and safety matters, gaining an understanding and nature of hazards and risks associated with the high-risk operations, providing and utilising the appropriate resources and processes to either eliminate or minimise those high risks, monitor information, hazards and risks, and respond in a timely way when inappropriate variations occur. Implement processes for complying with specific duties and obligations under the Act, including consultation and training. And then verify the provision and the application and the full implementation of all of the previous requirements. Now, these 6 behaviours, although not specifically required under the OHS Act in Victoria, are our legal precedents. They are implemented in most of the other states under WHS harmonised versions of these laws, and it is embedded in precedents in common law. And the particular common law case is Kumar versus Ritchie, where in New South Wales, a New Zealand director was heavily penalised for not demonstrating due diligence in terms of OHS matters. And it was an employee who was cleaning out a shipping container in New South Wales and then used an electric appliance which then ignited the fumes in the container. And although Ritchie and another director had general safety structures in place, they were not specifically targeting high-risk activities. And this was the criticism, and therefore the penalty applied. So due diligence must be focused. And the way to do that is to utilise these types of risk assessment tools and develop a risk register that specifically targets the high and extreme hazards and risks that the organisation may face. So this risk table, I've circled a few examples of the kinds of risk selections, the likelihood and consequence selections that will end up in the elements that we're talking about. And this is a table that is closely based on ISO, the international standard, ISO 31000. So it's very well regarded across the board. It is not the only tool, but it's one of the most widely used. So something like this or similar to for an organisation to develop its sense of how risky are certain behaviours, practices, features of a workplace. Now, a key point is this must be done in consultation as well. This is still only producing a series of subjective opinions. And the only way to give those opinions reliability is for groups of people to, reach consensus about the findings of these risk ratings or about particular tasks and activities. So a key thing about this is also that it must be based on good quality, detailed hazard characteristics. So the hazard must be well known. So one of the first steps is for an executive team or a board to have this risk register developed or something like it. So we've got, for example, the hazard category, which would be an electrocution, serious injury or death, needs to be considered. The contact, obviously, with live wires, perhaps during demolition, is the specific circumstance. And the current risk may be high, depending on how it's rated with the current controls, or indeed lack of controls. And then you can see there's quite a comprehensive list of controls that should, and for a high or extreme risk, these controls need to be selected and layered up so that if we can't completely eliminate the risk of electrocution, then all of these layers will help defend people and protect people against electricity becoming uncontrolled. And ultimately that might result in a residual risk from going from a current risk to high to a residual risk of moderate. And then please ensure that we have responsible people who are included, who can be the accountable ones, but it should not be just one person. So this is, I guess, what we call a risk register, and this should be, many organisations have a business risk register, but they do not break it down into specific injury-related categories, such as electrocutions, falls, vehicle pedestrian collisions, and the chances of those specific activities occurring. So this is one way to help plan for and avoid any chance of fatalities or indeed manslaughter prosecutions occurring. And this type of strategy document for leaders of an organisation will ensure that there is crystal clear line of sight for the leaders of a business on what is planned to be in place, and then you can audit to ensure it's in place in the long term. One of the things that organisations need to do here is develop a very long-term focus. Part of the nature of these rare and catastrophic events is that they only occur maybe 1 in 10 or 20 year periods. Many organisations have never seen these types of terrible incidents, and so they have no experience in these matters. So organisations need to think about long term and think deeply about how and when these things may occur. One of the criticisms for the Longford incident and the Royal Commission into ESSO around the Longford double fatality in Gippsland just over 15, 16 years ago was that ESSO were even obsessive about controlling lost time injuries, but had actually stopped or delayed thinking about the much more expensive and long-term risks around the ageing gas plant that was the source of the incident in Longford. So in addition to the need to, or another reason to think long-term is these penalties can be the result of serious illnesses that come from the workplace. And some illnesses take a long time to materialise. And so illnesses such as silicosis and asbestosis perhaps may be the subject of these particular legal changes. So the message here is think much longer term than perhaps organisations usually do. Usually return on investment calculations are 3 to 5 years. That can be problematic in terms of resourcing a business to have a much longer term strategy. When you're developing the mixture of controls, It is necessary that you develop the controls as per this legally required hierarchy. If you can, then eliminate the hazard from the workplace is the most beautiful solution. Most of the time that's not possible, so then the higher order, the more effective, the higher level controls need to be chosen. Sometimes they're more expensive up front, but we are talking about fatalities. It is problematic, indeed, if we select the lower order administrative or procedure or training or PPE controls to try and prevent against a chance of a fatality. They simply are, almost ineffective. So as we said, we need to layer up our controls and make sure that we're choosing the most effective controls within our capability as organisations. Again, this needs to be developed in a consultative approach. In particular, the health and safety reps need to be involved if and when they are in place in a workplace. Another component of these tests and the applicable duties under the Act is this one. And if we meet this test, then we comply with the OHS Act and the workplace manslaughter laws won't be of concern. So we need to, on the left, understand risk in terms of consequence and probability or likelihood as per the risk table we looked at. And on the right, then we need to select the most effective mixture and blend of preventative resources. There is no silver bullet on its own. We need to have a series of controls in place so that when one fails, if one fails, the other controls are defending people against, an escape or the hazard. So this is the test. And all applicable duties, or most applicable duties under the OHS Act, have this test in place. So we need to make sure, as I said, this is done in a consultative way. All of the experts, the hands-on experts, the practical, the process experts, and the technical experts need to be engaged. And an honest and open dialogue about the best ways that need to be adopted to control these high and extreme risk concerns and hazards. Reasonable time feedback, we need to provide protected time to develop this consultation and allow people to contribute. This is also a legal requirement. Giving people the opportunity to express their views is under Section 35 of the OHS Act. We need to consider language and literacy barriers or even cultural barriers that get in the way of good quality consultation. Please be mindful that we need to consult with contractors and subcontractors as well. There is a need for cross-corporate consultations in high-risk situations where we've got multiple organisations working on a site. And this is crucial so that things don't fall between the cracks. And a couple of the final things, or one of the key final things we need to do is to clarify and strengthen your corporate leadership attitudes. There must be a serious intolerance of high and extreme risks, and this must be ongoing and consistent across the board. Work must not proceed if the risks are intolerable. Intolerable means high and extreme, and they must be reduced to a tolerable level before work should proceed or can be allowed to proceed. This rejection of high and extreme risks must be durable, and it must be consistent throughout seasonal, busy or urgent business periods. It's not suitable that we do this on a part-time basis or when we have time. Any erosion of these leadership positions will lead to an increased tolerance of dangerous situations and practices. And that might be fine for 5 years, 10 years, but then a series of terrible things will occur. And so we need to be vigilant and consistent, again, in the long term, to make sure these leadership attitudes are strong and unwavering. They need to be applied consistently and without fear or favour. And again, translating and communicating these attitudes, these intolerances to high and extreme risk to and through contractors and subcontractors as well. We need to finally gain evidence and assurance, documented and written, evidence and assurance to ensure that the things that we intend to be in place are indeed in place and working. And so we need to, if we can't fully eliminate them, then as per our risk register and strategic action plan, measure, monitor and receive information that what we said we want is in place. 100%, sorry, using lag and lead measures, in particular lead measures that focus on items such as 100% of safety inspections are completed as per various schedules. 100% of IHS meetings are held and consultation is effective as per plans and schedules. Things like specific hazard action plans are fully implemented. These things are all measurable and reportable, and certainly need to be, no matter if we've got, again, contractors and subcontractors on site as well. There needs to be a combination of internal hazard and perhaps behaviour auditing around safe practice, but also making sure that the frequency of the various feedback mechanisms suits the level of hazards and risks. It's not appropriate for high or extreme risk to be inspected once every 6 months. That does not work. We also need to build in less frequent but more comprehensive external independent auditing, so that our, just to compare and validate that our internal information is accurate and meets the requirements of external experts. And then finally, written periodic assurances from those in our organisation and contractors who are responsible for implementing these safety requirements. There are a few industries that stand out in this sector. There is a few, when we look at work safe fatalities data, you can see that businesses such as agriculture, construction, manufacturing, transport and warehousing, and we have included electrical, gas and water industries in our tip sheets as well as another industry that is high risk. And so, these industries are the ones, I guess, that frequently occur in the data, in the fatalities, and therefore need to be the frontline industries that improve these practices. And as I said, our tip sheets are designed to reflect these particular industries as well. So I guess just in summary, before we go open to questions, just summarising this 5-step process is, conduct formal fatality hazards risk reviews, build a business risk register for specific fatality and serious injury illness situations, develop a strategic action plan that your organisation then must follow. Ensure this is implemented in a full and consultative way, again, a legal requirement, and seriously consider and plan how to avoid the rare and catastrophic hazards and risks. And a reminder to think long term. Again, these can be 1 in 10 or 20-year disasters that sometimes corporate memory either has no experience of or has lost and forgotten how terrible these disasters have been. So strengthen corporate attitudes so that those attitudes remain strong over the long term and there's a serious intolerance of everyone accepting high risk activities just to get things done. And so again, assurance and monitor that the controls that you require are then in place and effective. Written evidence and regular feedback. Okay, so thank you. I'm going to ask Phyllis now if you'll summarise the questions that have been posed. So thank you, Phyllis. We'll endeavour to respond to the questions that have been asked.
Thanks, Ian. We've got 4 questions so far. The first one is, are there any examples of the law applicability in family or community services sector?
Yeah, very good question. Certainly there are, in terms of the OHS law prosecutions to date, there are less of them. In the UK, in the 26 cases, there aren't any in that particular group. We've got no precedents for manslaughter in that industry so far, but we have no precedents anyway. But certainly there are some community services and other organisations who are prosecuted for other reasons under the applicable duties. So there is a chance in the health sector, because they are workplaces, and they're, all workplaces will be subject to these laws.
And staying within the industry sectors, are there any examples from the UK outside the manufacturing and warehousing sectors, such as community services, looking at cases of injuries that employees are caused by violent or unstable clients?
I don't recall seeing the UK corporate manslaughter prosecutions dealing with those, but again, the numbers are low for corporate manslaughter in the UK. There was a case that was thrown out, where someone, or a case was brought against the NHS, the National Health Service in the United Kingdom, but the case was unsuccessful in that. I'd have to go back and check the details of that. But I will go back and have another look, because what we'll do with these questions is we'll publish a Q&A fact sheet in response to these as well. So I'll go back and have another look to see if I can see anything that might indicate that. But generally, the health industry is less represented than the other high-risk industries across the board.
And moving on to risk management, is it the inherent or the residual risk rating that should be used?
This is a choice of your organisation. Now, some organisations choose to start with the inherent risk. And for electrocution, for example, then that's the raw energy of 240 volts, or indeed 11,000 volts if it's high voltage. Most organisations adopt a starting point of with current controls, and then move to a point, well, what extra controls do we need to put in place to ensure that our risk is then reduced? But most organisations adopt a current controls stance in terms of their current risk, and then consider what else do we need to do.
And moving on to the cost benefits, could you please advise the role that cost plays in choosing safety measures?
Yeah, I mean, that's very well established in the reasonably practicable test. If you remember the scale, and you can go back and look at the scale in the slides. So we've got risk on the left-hand side of the scale in consequence and likelihood. And then on the right, we have the resources a company needs to provide. Now, they're broken into 3 categories, and this is listed in Section 20 of the OHS Act. The state of knowledge of a company, the expected state of knowledge, the availability and suitability of the controls to control the fatality, hazard and risk, and finally cost is the component that it is considered and is allowed. But how, what is a life worth is a normal following question. It's in the, multiple tens of millions of dollars if we actually, try and put a figure on it. So basically, when we're talking about fatalities, it's everything in a company's capacity needs to be applied. And it's in the multiple millions for sure.
And the last question we have is, if working with high-risk clients and if you don't have good plans around them and the client gets hurt and kills a staff member, could the organisation be found to be negligent or at risk of manslaughter legislation?
In short, yes. There are, quite a few current prosecutions that involve multiple parties. So, we've had up to 3 or 4 organisations prosecuted in separate hearings for the same incident. And so this continues. So these duties are shared, and absolutely we can have, the principal company, but also subcontractors and subcontractors, for example, prosecuted for the same incident. Now, a way to avert that is to be really clear and plan up front to make sure that the planning is in place to ensure things don't happen. And it's really clear about the principal company's role and the contractor's role and who is going to manage what. And build that into a contract so that it's clearly stated and agreed to in law. So that's, I guess, the first thing. And then there's, practical supervision that goes beyond the contract as well.
Yes. I've got one more question, Ian.
Good, thank you.
It sounds like the due diligence has now been introduced into the OH&S Act. Is that correct? I guess you can say, to put it simply, it is implied as an expectation. It is not expressly stated. We are including the due diligence behaviours as a pathway for organisations to make sure that they avoid any manslaughter. But it's not expressly stated in Victoria, but it is common law precedent. And I mentioned Kumar versus Ritchie for that reason. And so if any magistrates are considering due diligence, they will look at those precedents and look at the other states and their express laws around due diligence as well. Oh yes, there is one more. In regard to volunteers.
Yeah.
If a volunteer causes the death of a person, then are they responsible?
As stated, under the workplace manslaughter provisions of the OH&S Act, they are excluded. However, the other provisions of the Act, such as Section 21, Section 25, employees, Section 26, those who manage and control, can still be used and still may apply for volunteers who may actually be, linked to causing a fatality. That said, then you have the other laws under criminal manslaughter, under the Crimes Act, but you also have the Corporations Act that does deal with this in some way as well. And I'm not an expert in the Corporations Act, so I'm not going to try to talk about that, but I know, there's a nod, if you like, to corporate and corporate officer behaviour there. So under the OH&S Act, there are exclusions and specifically for workplace manslaughter.
That's all.
Okay. Thank you, Phyllis. Appreciate your assistance. Thank you, everyone. I hope you've gained a lot of value out of our webinars. This is, as I said, we will send the recorded and the slides and the quick Q&As to you as well. And if you need any help, then we're here and love to assist. So thank you all, and hope you have a good day.